All right, we're back on then. Counsel present, our defendants present represented by counsel. When we broke, Mr. Rubin, on behalf of Travis McMichael, had completed his presentation to the court. Greg McMichael.
Your Honor, I want to begin by just addressing some case law that seems to apply to the, I want to say, piling on of the additional felonies, and that they do not merge, which is the state's position. I point the court to Noel versus the state, 297 Georgia 698, a 2015 case. And it says, in fact, what Ms. Dunikoski's position is, that the additional felony murder counts will be vacated by operation of law when they involve the same victim. But in that case, there was, as there is in this case, additional felonies, which in Noel there was a question about whether the trial court should have also sentenced and not merged those into the felony murder counts, which were vacated by operation of law. I want to make a separate argument. This is the first time we heard of this morning. I know of no law that prohibits the court from conducting merger before the vacating of the by operation of law. So in other words, if you were to merge the underlying felonies into the felony murder counts, and then those counts are vacated by operation of law, we don't even need to consider this. But in Noel, this Georgia Supreme Court case, this court concluded that the trial court had failed to sentence on the underlying felonies that were the predicates for those felony murder counts that were vacated by operation of law, but did not automatically say that the trial court erred in not sentencing on those. In Noel, the Supreme Court ordered the trial court to make a determination, and I quote, whether the remaining non-murder felonies merge as a matter of fact into the felony murder conviction, and that's why the case was remanded back. And interestingly, in the Noel case, the Hewlett case is cited, 296 Georgia 49. That's a 2014 Georgia Supreme Court case. Same issue as before about the felony murders being vacated by operation of law. And then but in Hewlett, it was a malice murder case as well. But it gave some instruction, and I suppose that's why the Noel court relied on Hewlett, gave some instruction about whether there would in fact be merger. And in Hewlett, the important distinction was whether the felony that then led to felony murder was followed almost immediately by the death of another. So the question was whether there was a, quote, deliberate interval between the offense and the death. For those reasons, Your Honor, I ask the court to find as a matter of fact that those felonies do merge and that there is no reason and no statutory obligation for the court to sentence on the other remaining felonies that the state wishes to proceed on.
So I understand what you're saying. What you're saying is there's no deliberate interval then, because there are other cases.
Yes,
you gave me that.
I just realized that I put that. Yes, that's exactly what I'm saying, Your Honor, that all of this took place in a continuing manner, that there was no stop and start between the beginning of the chase, we'll call it, and the end, which led to the tragic death. So for that reason, I think that it can be distinguished from some of the other cases that Ms. Dunikoski may be relying on But it certainly stands for the proposition that simply because the felony murders are vacated by operation of law does not mean that the underlying felonies have to be sentenced upon. They don't still exist. They aren't still there. There still is a question of merger by operation of fact.
Okay.
All right? Between the two statutory sentencing options that are before this court, the state is asking for the sentence of life without the possibility of parole. And they made that position known back in September of 2020, specifically September 16th of 2020, when they filed a notice of the state's intention to introduce evidence in aggravation of punishment. And in that notice, Your Honor, under the final box that's checked, the state indicated that it intended to seek life without the possibility of parole by relying upon three statutory code sections: 1651, which is simply the murder statute; 1710-2, which is the statute of criminal procedure that provides for what we're doing here today, the presentation of evidence in support of any sentence that each party is seeking; and finally 1710-6.1 is the third code section on which the state relied in seeking life without the possibility of parole. And in that code section, that is, as the court knows, sets forth the inability for any individual who is incarcerated for the first time on an aggravating, on a violent felony, which results in a sentence of life with the possibility of parole, to not be considered for any form of release or parole until after the service of 30 years in prison. Those were the reasons, the state said, we seek punishment of the defendant in this manner. And at the top of their notice of seeking aggravation of punishment, the state indicated in September of 2020 that they intend to introduce evidence of any convictions, juvenile adjudications, and other crimes of the defendant furnished as part of the reciprocal discovery. What the court knows is that there are no other crimes and no other pieces of evidence that support that statutory ground for seeking aggravation of punishment. So in the absence of that sort of evidence, which is the evidence the state indicated back in September it would provide, an absence, as the court knows from the bond hearing and having had those documents provided to it, there is an absence of any criminal history by Greg McMichael, which is a significant factor in your consideration of what sentence to impose. So, without any of the aggravating evidence that was set forth in the notice, the state has told this court now, we wish to simply rely on the facts of the case. And in particular, what Ms. Dunikoski argued is, number one, what she called a pattern of vigilantism. But every example she gave, Your Honor, was not, in fact, vigilantism, gathering up folks who have no authority to do so and taking the law in your own hands. Her examples were notifications that Greg McMichael made to law enforcement about suspicious activity and suspicious people in their neighborhood. And in fact, that is exactly what a neighborhood watch program is all about. That's what Officer Rash testified to you we can't survive without neighbors who will let us know what's going on and provide us the evidence we need to investigate crime. Very different, and not at all related to some sort of pattern of vigilantism, which is a violent act. The second fact on which the state said that they were relying, based on the facts of the case, to seek an aggravation of punishment from a life with parole, meaning no consideration for anything less than 30 years, all the way up to life with absolutely no window of opportunity, is that Greg McMichael has shown no remorse or empathy. The difficulty of our adversarial system, a system that is the best system we know of, is that it still leaves no opportunity for an accused to turn and be the person you know he's been for 30 years, for 66 years, and offer condolences to another person for their sadness and for their loss. The other problem with the adversarial system that I know all too well is that an individual who is committed to telling the stories, to explaining to a jury how an individual got where they are right now, often feels like a defense attack on the surviving relatives of this loved one. A vigorous defense often results in the sadness of people who have lost a loved one. But those are the roles that we honorably take on. Our remaining stoic in the face of heartbreaking testimony this morning from people who have lost a loved one is because that's our role in this courtroom. This court has very handily taken care of emotional outbursts to make sure that we're dealing with law and facts and not the kind of thing that can otherwise affect a court or a system that should remain free of those sorts of emotions. So, Your Honor, like Mr. Rubin said, it really isn't anything that I suspect the court will be taking into consideration, the fact that Greg McMichael didn't and couldn't stand up and offer his genuine sadness and condolence for the loss of a loved one, because he's facing other crimes. He's facing charges and trials on other crimes, criminally and civilly. And I hope the court knows that what we need to do to tell his story in any case involving justification, of which there was sufficient evidence to move forward with a request to charge, is that there has to be a clear, palpable, full-throated explanation to a jury about how it is that an individual put himself in a place where our clients felt they had to defend themselves. It must be terribly difficult to hear when it concerns your loved one who's no longer here. And it probably feels cold. But the court knows those are our roles, and it's the only way to make sure that our system operates as it should. So, Your Honor, with no statutory aggravating circumstances, like in a death penalty case, how do you decide? We now know there are no statutory aggravators based on the notice. We now have told you about how the factors that the state said arise out of the trial actually escalate this out of life with parole to life without parole. I suggest to the court that we rely on a wonderful system that the federal United States sentencing guidelines set up and the United States Code, and that's you look at two things. You look at the nature and circumstances of the offense, and you look at the history and the characteristics of the defendant. Let's talk, number one, about the nature and circumstance of the offense. The best indicator of what happened in order to respect the jury's verdict is to listen to the jury's verdict. The jury found that Greg McMichael, as a party to the crime, committed felonies that unintentionally led to Ahmaud Arbery's death. After deliberating for over 10 hours, over 2 days, they came back with a unanimous verdict that says, in effect, Greg McMichael did not leave his home that day hoping to kill. He did not view his son firing that shotgun with anything other than fear and sadness. What this jury found is that this was an unintentional act, one that Greg McMichael did not plan, devise, attempt, or seek to have the result that happened. So if life without parole is a sentence that is held for only the worst of the worst, it simply can't be a sentence for a person who never intended that tragic result that took place on February 23rd. If you never wanted another person to die as a result of activities you took part in, you can't be the worst of the worst. Secondly, Your Honor, under 1710-2, the things that this court should consider, you should take in account extenuating or mitigating evidence that you heard in trial. You heard in trial, based on the presentation of evidence over several days, that Greg McMichael sought to detain Ahmaud Arbery for one reason and one reason only. It was not for sport. It was not for evil. It was for the same reason that the police who repeatedly came to Satila's shores came there for. It was to get to the bottom of Ahmaud Arbery's nighttime intrusion into Larry English's house. The verdict spoken by this jury, based on their understanding of the law of citizen's arrest, found that Greg McMichael did not possess the information he needed to possess to attempt to execute a citizen's arrest, and that meant that Travis was not in a position to defend himself because he was the initial aggressor, if there was no citizen's arrest that could be supported by the facts and the law. That is the offense that you heard. A reason that is not an evil reason, not a reason of hate, not a reason of anything other than trying to help other people to get to the bottom of this inquiry. Further support of extenuating and mitigating circumstances from the trial you saw in the video itself. As painful as it was to watch, I'm sure the court does recall that when you saw Greg McMichael in the back of the pickup truck, in the bed of the pickup truck, not directing, not doing anything that's going to be the person who's advancing the progression of this from the chase, the attempt to stop and detain Ahmaud Arbery, into what it ultimately became, you most importantly saw that Greg McMichael never even sought to remove his handgun from its holster until after you heard the first shot that took place in front of that pickup truck. So while he's on the phone begging for 911 to come and help, that is the moment he removed his handgun and never fired a shot. That is the nature and the circumstances of the offense that this court heard and upon which the jury reached their verdict. So now, the history and the characteristics of Greg McMichael. Because we know that history is the only reliable measure of a person's character. Greg McMichael is 66 years old. So, Ms. Dunikoski, there has not been just 99 good deeds, but more like thousands and thousands of big and little good acts of kindness, charity, goodwill throughout this man's life. Greg McMichael is a good man. He's not a perfect person. None of us are. But he's lived a good life, a life dedicated to service. And that does count for something. The choices he made as a young man, all the way through the rest of his life, to serve, not to acquire wealth, not to do anything that brought extreme attention to himself, but to quietly go through the business of choosing career options to help other people. You heard at the bond hearing and during the trial of this case, Greg McMichael chose as a young man to serve this country by enlisting in the Navy. And after an honorable discharge, some years later decided to serve his community. Over 30 years in law enforcement. He was not a patrol officer, then later a detective, then later an investigator with the DA's office because he sought power. There was no evidence of anything like that. There were never any complaints about him being aggressive, about him seeking to take matters in his own hands without seeking the appropriate backups. He was not a gun-toting, aggressive officer. His wife testified during the bond hearing. One matter of pride that Greg McMichael always had is that he never had to discharge his weapon during the service of his community. And of course, he wasn't a law enforcement officer or an investigator for the DA's office for money. That's laughable. He did it to help, he did it to serve and protect other people. His post file that the court had into evidence during the bond hearing indicated numbers of commendations and notes from people in the community indicating how grateful they were for his willingness to participate in a case, for his willingness to go the extra mile, for his kindness to families of people who had lost loved ones. Things that are above and beyond the work that he needed to do. Those examples of commitment, of empathy and kindness are further examples of who Greg McMichael is. He is a husband for over 38 years through thick and thin to the woman that he met and married months later. He's a son, a brother, a father, and a devoted grandfather. So yes, that's how I stand before you, Your Honor, representing Greg McMichael, who has now been convicted of murder, and I say without hesitation, he remains a man of goodness. For 66 years, I calculated that's 24,105 days of life on this planet. And we're here, not for a small matter, not as if all of the other erases what happened on that day, but we are here for a driveway decision to pursue Ahmaud Arbery and a 5-minute chase that ended in tragedy. He needs to be punished. But how that contrast between a life of goodwill and service and the bad decisions that were made that day that resulted in a tragedy that the jury said unanimously he never intended could end up in the state seeking the sort of sentence that is devised for the worst of the worst is not consistent. In many courtrooms, Your Honor, that I appear in, right behind the judge, and it might be that way in Chatham County, there is the seal of the state of Georgia. And our Georgia state seal has 3 words on it: wisdom, justice, but most importantly, moderation. Life without parole versus life with the possibility of parole may be nothing more than academic for a 66-year-old man with significant health problems, because it means 30 years, at the very least, in prison. But it is an important distinction. It will affect all sorts of other things that could happen to Greg McMichael while he's in prison. But most significantly, it is the only way, Your Honor, to honor the jury's verdict that Greg McMichael committed crimes for which he never intended the result. For that reason, for the lack of evidence of aggravation, for the presence of significant evidence of extenuation and mitigation, we ask the court to sentence Mr. McMichael to life with the possibility of parole. Thank you.
Mr. Goff.
Your Honor, we're going to need a short recess before we proceed. I need to triple check a matter.
Okay.
A 5-minute recess should be sufficient.
All right, well, let's make it realistic. Let's take a 10-minute recess, and then we'll come back on the record at 1:45. Thank you. All right, we're back on. Defendants present, represented by counsel. Mr. Goff.
Your Honor, let me begin by making clear that nothing I say should constitute a withdrawal or abandonment of any other sentencing-related or punishment-related motions previously filed. Beyond that, if this were any other case, when it comes to sentencing, I'd be turning to Ms. Dunikowski and saying, Judge, what she said. I agree in a lot of ways that the sentence recommended by the state should be the judgment of the court. But this is not a normal case, and out of an abundance of caution, I do feel like I need to address a few issues, but I'll be relatively brief. And there is one issue that the state's sentencing recommendation did not address. I'm pretty sure I know what the answer would be. It won't take them long to give it, but I would put it on the record. Your Honor, like Travis and Gregory McMichael, Roddie Bryan is a first offender. He has no prior felony convictions. Like Travis and Greg McMichael, Roddie Bryan has lived a life, however well lived, that warrants an opportunity and potential for redemption and rehabilitation. I would ask the court to consider the entirety of the record in the case, including the transcripts of the pretrial proceedings, including the bond hearing in this case. I'm not going to go through a whole bunch of Roddie's family history and circumstances. I know the court is familiar with them. The McMichael defense teams have argued elegantly and persuasively for sentences of life with the possibility of parole, based on the grounds that I've previously discussed. And like the McMichaels, there's no evidence that Mr. Bryan is depraved or among the worst of the worst, and therefore Roddie Bryan should likewise be allowed the possibility of parole. And there is an argument here as to whether or not the life without parole option is an option before the court in this case. I didn't think the state had filed a notice of intent to seek life without parole, and apparently they did file the notice. I'm not sure whether they had intended to withdraw the notice beforehand or what happened, but in this case, the notice, which I don't recall receiving, was filed in September 2020. It was emailed to a Sea Island address, not mine, which would be consistent with it not having been properly served. And I would take the position that due to a technicality beyond the control of the state in this case and beyond the control of the court, and the service was by the previous Chief Assistant, Jesse Evans, in this case, that technically, not having been served as provided in the certificate of service, that the notice is defective. There still remains an issue as to whether the court can could impose sentence anyway without that notice, and that would require the court's resolving two competing statutes. You have the sentencing statute itself, and then you have 1716-4 under which the notice was provided. We would suggest a rule of lenity indicates that where the notice has not been served, or there's not proof of proper service, that the court doesn't have discretion to impose a sentence of life without parole. I'll let the court think about that. It may be an academic question anyway, particularly given the state's recommendation, which we're certainly not going to disagree with. But going beyond that issue, Your Honor, while Mr. Bryan is also a first offender and also worthy of rehabilitation based on the life that he's lived, as the evidence reflects, that's where the similarity between Roddie Bryan and the McMichael defendants ends. And I would submit to the court that that isn't the beginning of the sentencing inquiry for Mr. Bryan. The end of the sentencing inquiry for Mr. Bryan, I would respectfully submit that it's the beginning. Now, before getting into that, I do want to address one other, lawyers probably shouldn't use the word technical arguments, but I would contend that count 9 merges into count 8. I don't think alleging separate streets that the chase is occurring on changes it if someone was chased through the city of Savannah, I don't think that you could argue that there were 15 different attempts at false imprisonment or 15 different false imprisonments. If you went down Montgomery and up MLK and across Broughton and up the President and down Julian, I don't think you could multiply counts that way. I do think that 9 is an inchoate offense that obviously merges into 8. And because the motor vehicle that was used in this case was used in the context of the chase, there's a factual merger. And I think it's more or less the same argument that Ms. Hogue was making, but I could be mistaken. And so I want to adopt her argument as well to the extent it's expansive beyond mine, and specifically a recitation of the Knoll and the Hewlett cases. Having done that, I want to get into what I think is where the sentencing inquiry for Mr. Bryan really begins, because this is a kind of unusual case. To me, there are 4 additional factors that the court has to consider in fashioning a sentence here. And then the question becomes how the court does that under the laws of our state. We've already challenged those laws. The court, not surprisingly, given prior decisions of our Supreme Court, whatever standards may be evolving until the Supreme Court says they have, this court applies the law that we have. But there are 4 factors here that I think the court has to the court never has to consider anything I think the court should consider. Issue number 1 is the jury verdict says that Roddie Bryan was not a party to the shooting, nor a shooter. Roddie did not kill Mr. Arbery. He did not attempt to kill Mr. Arbery. He did not intend to kill Mr. Arbery. He had no idea that the McMichaels had guns until moments before the shooting. And that's not just an opinion. That's pretty much a jury verdict. When they acquitted Mr. Bryan, not only at count 1, but also count 2 and count 6, when they found him not guilty of anything related to the shooting, that's a reflection of the fact that Mr. Bryan had no idea of what was about to happen. That tragedy was certainly not something that he could have anticipated up until the moments before. And by saying that, I'm not trying to get back into the charge conference issues. It's a different factor here at sentencing. But Roddie Bryan was not a vigilante. He was not a party to any organized effort to fight crime in Satilla Shores. Roddie Bryan really had no idea what was going on or why until after the tragic death of Mr. Arbery. And I think the state pretty forcefully drove that issue home during its closing argument in this case. That factor really puts Mr. Bryan in a different position. Mr. Bryan isn't the one who brought a gun. He was unarmed. And I think that reflects his intentions and it reflects a significantly lesser state of culpability. The second issue, Your Honor, is the issue of remorse. Now, like the McMichael defendants, Mr. Bryan faces a federal trial and substantial federal penalties in the event of a conviction. I would agree with Mr. Rubin that no competent attorney in the state of Georgia under these circumstances would allow a defendant to say anything more than they already have. But in this case, distinguishing again Mr. Bryan from the McMichael defendants, Mr. Bryan has expressed remorse. Whether it's part of the record or not, he expressed remorse about Mr. Arbery's death even before he was arrested on national television. As the Arbery family, of course, has not accepted that, and they don't have to, Your Honor, and we can all understand why. But beyond that, when you look at his statements in this case, I think it is readily clear that while Mr. Bryan has disputed and continues to dispute whether things that he did that day constituted crimes, he has never questioned the tragedy of this death and has never expressed anything but remorse over the death of Mr. Arbery. And that does put him in a very different category, I would submit, and a very different posture from the other defendants. And I would remind the court, and I'm not going to spend a lot of time on it because the court heard most of this, but during the trial, the court heard the body cam from Mr. Minshew. Mr. Bryan admitted from the get-go that he chased after Mr. Arbery, that he was uncertain as to whether they should have done that. He wasn't running around the scene trying to influence witnesses' testimony, as the state alleges other people have done. He was very candid and straightforward, and you heard his demeanor on the video at the crime scene. You heard the excerpt from the interview with Detective Lowry, and of course the court has the entire statements in the record, where Mr. Bryan expressed, again, regret that Mr. Arbery died. He pointed out that, if his vehicle had collided with Mr. Arbery, maybe Mr. Arbery would still be alive. And not in the context of wanting to hurt Mr. Arbery, but in the context that maybe he would still be with us, and this tragedy might have been something less. Beyond that, Your Honor, there were a number of statements made to investigator Sechrest, Special Agent Sechrest, during the investigation of this case, which technically, I believe the statements themselves, the transcripts and the videos, were admitted into evidence at the Jackson v. Deno hearing. At least that's my practice. I don't have a transcript to look at, but that's normally what I do. And moreover, I think they were tendered in connection with the preparation for the trial itself, and I think technically during the trial, although they weren't presented to the jury, but the court can consider those. On May 11th, Mr. Bryan, I'm referencing page 69 of that transcript, indicated that he did not want to see the video in the aftermath of the shooting. He didn't enjoy it. He didn't take any pleasure in that. On May 13th, at page 75, Roddie Bryan expressed shock to Agent Sechrest at the shooting of Ahmaud Arbery. Referencing page 100 of the transcript, Roddie thought it was that what Mr. assumed, thinking might be putting too much credit to Mr. Bryan, Roddie Bryan assumed that Mr. Arbery had done something more serious, that there was more to it than going through an open, unsecured construction site. And that doesn't change the lawfulness or unlawfulness of his conduct, but it does reflect on his level of remorse. At page 101, Mr. Bryan says that to Agent Sechrest, and these are all statements that the state could have used at the trial against him had they wished to do so, and may still be used against him in federal court. None of these statements are without consequence. That he was sorry that Ahmaud Arbery died, that he wished he had stayed on his front porch. He's not going around boasting to people or bragging about it. He's regretful way back then. And that is before he was arrested. At page 102, he regretted having got involved in the chase. And, Your Honor, I think when you take those statements in conjunction with the rest of the evidence in this case, Mr. Bryan has done everything he could do, short of confessing to committing felonies on national television, that he is remorseful and regretful at this tragic loss of life. And it's difficult for me to conceive what more he could do. Now, is the Arbery family going to be satisfied with that? No. They don't have to be satisfied with that. You have to give credit. 3 members of his family came up here and probably did what were the most difficult things they've ever had to do, is to come speak here in this court on national television effectively about the death of their child and their brother. And that's difficult. But whether or not they accept Mr. Bryan's expression of sorrow and remorse for the death of Mr. Arbery, it's for the court to decide whether Mr. Bryan has expressed remorse, and if he has, what to do about it. And the court may well decide there's nothing the court can do about it. The felony murder statute prescribes one punishment, a mandatory minimum of life. And I'm not reviewing the legal argument there. But if there's a way the court can take it into account, I'm going to argue that the court should. The last issue, Your Honor, and I think the court is well familiar with it, is Mr. Bryan's full cooperation with law enforcement from day one, from moment one, from minutes after the shooting. I'm not going to belabor all the different things Mr. Bryan did, producing the cell phone, the night out video, the numerous statements, going through the area where the shooting took place with the police to help them understand what happened that day. On a scale of cooperation, you'd have to put Mr. Bryan at a 10 out of 10, even a 12 out of 10. I've never seen a defendant provide that kind of cooperation. Most of it without the benefit of counsel. Slick lawyers didn't tell Bryan to turn over the cell phone, to talk on the scene on the body cams, to go down hours later to the police department. Bryan did that because he wanted the truth to be known, whatever that was, whatever it meant. So these are all factors above and beyond anything that apply to the McMichael defendants as to why Mr. Bryan should receive a lesser sentence. Now, the mandatory minimum in Georgia is life imprisonment on a felony murder. I'm not going to rehash the legal arguments. What I am going to suggest to the court, though, and given the age of the defendants here, whether Mr. Bryan is eligible for parole or not, he's going to be 80 years old under the current guidelines before he could be eligible for parole. And effectively, even if the court grants life without parole sentences, as the state has requested, to the McMichaels, simply giving Mr. Bryan a sentence of life with the possibility of parole, still, given the respective ages, means that he would essentially serve the same sentence and that there would be no options there. So I'm asking this court to consider sentencing Mr. Bryan and Mr. Bryan only under OCGA 17-10-1B, which, at least in my experience, is relatively rarely employed, but perhaps underused, especially given the evolving standards of with respect to sentencing issues. Under 17-10-1B, as I understand it, a request for relief from parole restrictions may authorize consideration by the parole board of parole prior to the completion of any specified time period otherwise required prior to parole eligibility. Imposing sentence under this statute does not grant Mr. Bryan parole. He still may never receive parole. He could still die in prison 50 years from now, even if the court grants relief under 17-10-1B. All that does, however, is it gives the parole board the freedom, if you call it that, the ability to parole Mr. Bryan whenever they see fit, regardless of any statute or rule that would otherwise prevent it. Now, Mr. Bryan still has a long road here to establish the redemption and the rehabilitation that would justify his ever being released from prison. So, as I've explained to Mr. Bryan, this doesn't guarantee him that he would do 1 day less in prison than he would otherwise do under the sentence that the court is about to impose. But what it does do is provide the opportunity for the parole board to exercise its discretion in deciding whether to release Mr. Bryan when they believe it would be appropriate and not based on some arbitrary, preconceived, mandatory minimum time period before he could be considered. And I believe that this is that rare, exceptional case where relief under 17-10-1B, however fleeting it might be, depending on the circumstances, that this is a case where that would be appropriate. And I would respectfully submit to the court that as a practical matter, it's really the only relief that the court can give Mr. Bryan to reflect his cooperation, his expression of remorse, and the other factors that I've reviewed with the court today. And that doesn't change the sentencing recommendation. I'm concurring with the state, putting aside the legal arguments about merger and vacating of sentences. I'm agreeing with them that the sentence of life plus 15 consecutive probation, that would be the appropriate sentence in this case. I think the only thing that we really are disagreeing about at this point is I'm expecting the state is not going to be excited about 17-10-1B, but I'm asking the court to do that anyway. And in this relatively small instance, and again, it may be completely meaningless depending on how the parole board views things 10 and 20 years down the line, but it is really the only thing, short of striking down parts of Georgia's sentencing law on constitutional grounds, it's really the only thing this court can do that would substantially reflect the wide chasm in differences in culpability and other issues between Mr. Bryan and the McMichael defendants. It's all that this court really has available to do that. And if for no other reason, why I would ask the court to do so. But I do think it would be in the best interest of justice. I mean, Your Honor, Roddie Bryan probably, I won't say he's unique, but he's as close to unique as you can get in our criminal justice system. It's a felony murder for someone who didn't kill or attempt to kill or intend to kill, and it's in the context of a citizen arrest, however foolish and badly guided and misinformed, and certainly however unjustified under the law. There probably isn't another individual in the entire Georgia prison system that's in a similar posture, and thanks to the changes the legislature has made to the citizen arrest statute, it will certainly never be an issue again. So this is a request that we're making here on behalf of Mr. Bryan that would effectively impact one person now or in the future in the state of Georgia. And we're not asking that as special treatment for Mr. Bryan. We're asking it as treatment that anyone in his situation would be asking for, given the totality of circumstances present to the court. So again, we're asking the court to impose a sentence of life imprisonment plus 15 years, but we're also asking the court to grant relief under 1710(1)(b). Thank you, Your Honor.
Thank you, Mr. Goff. From the state.
Thank you, Judge. Because there's a number of legal issues as well as additional argument by the state, is there any particular order you'd like to hear it in? Would you like me to start with Mr. Bryan first and work backward, or just go from Travis and...
Why don't we, however the state wishes to present it, I'll be able to follow it, I would imagine.
Wonderful. Okay, Judge. So regarding Mr. Bryan, with regard first to this parole board issue, 1710(1)(b) actually says that it will apply only to first offenders, where technically Mr. Bryan is a first offender. He doesn't qualify under the first offender statute because anyone convicted of felony murder, you're not allowed to sentence them under the first offender statute. So we have that problem first. But the second problem is that it refers back to A. And subsection A of 1710(1) actually says, except in cases in which life imprisonment, life without parole, or the death penalty may be imposed, and then goes through. So B can't even apply to anything that imposes a life sentence. And that's how the state is reading this, because when you look at B, the judge in fixing the sentence as prescribed in subsection A of this code section. Subsection A says, except for life sentences. So therefore, none of this will ever apply to a felony murder conviction. And then, looking at count 9, merging into count 8. I understand factually the issue that Mr. Goff has brought up on behalf of Mr. Bryan, that two separate instances, one an attempt to confine him taking place on Burford, was just a continuation of something that was going on and on and on and on. Ironically, that was not the argument that Mr. Goff made at trial during his closing argument. He actually started to posit that Mr. Bryan was actually leaving and wanting to go home and just happened to go in the wrong direction back down Holmes, and that he wasn't actually trying to commit a false imprisonment on Holmes. He was just trying to go home. But regardless, what we have here is an intervening factor. I didn't know Mr. Goff was going to make this argument, but I believe there's a case out there that involves aggravated assault and aggravated battery. And it involved a man who had cut the female victim's throat and then also cut her face. The aggravated battery was on the face, the aggravated assault was on the throat, but there was an intervening time frame. And so on the one hand, I do know that there are numerous cases out there where if you start shooting at somebody and then continue to shoot, it's all one aggravated assault. Okay, there aren't separate aggravated assaults for each time you fire, unless there is an intervening actual time frame where you've shot, they've run away, you've chased them down, and now you're over on another street, like we have in this case. You've encountered them again, and now you start shooting again. Because there's two different locations, two different specific places and times, that allows the state to charge it. And the reason it allows the state to charge it is because what you're really trying to do is prevent the state from engaging in double jeopardy. You don't want the state to be able to go on January 3rd on Burford, no, on, well, I'll do our case. On February 23rd, 2020, on Burford, you attempted to falsely imprison him. Oh, not guilty. Okay, well, we'll go ahead and move it over to Holmes, and we'll get a new indictment, and we'll do it over there on that date. So you want to keep the state from going ahead and doing two different things in two different bites of the apple. You want to make sure there's no double jeopardy here. Well, in our case, we don't have double jeopardy here because we have two different separate instances, and they're both in this indictment, and they're both two separate time frames. Yes, very close in time, between 4 minutes. I know I'm kind of giving the court both the defense side and the state side, but to be candid with the court, there are cases out there, especially the gunshot cases, that say it's all one continuous action. The state's position in this indictment, and one of the reasons we specifically indicted it this way, is because Mr. Bryan's attempt at false imprisonment on Burford was specifically done with his pickup truck when he tried to run Mr. Arbery off the road and tried to attempt to falsely imprison him right there with his truck. He attempted 4 different aggravated assaults on him at that point in time to get him to stop there. He was unable to do it. That's why it's a criminal attempt. However, over on Holmes, after he went up and chased him up, and then we begin the video, and Mr. Arbery turns back, Mr. Bryan does continue to go up Holmes. He actually goes up Holmes. It's on video. He pulls into a driveway. He says, I'm going to go ahead and keep going. He does a 3-point turn, and then he comes down Holmes. He encounters then Mr. Arbery coming around the corner, and that is where that actual false imprisonment absolutely takes place, right there on Holmes, where Mr. Arbery is ultimately falsely imprisoned and killed. So these are two separate, distinct incidences, and there is no chance of double jeopardy because both of these things are distinct. They took place at separate places and separate time frames within the incident. So we ask that count 9 not merge into count 8 for Mr. Bryan.
I'm sorry to interrupt. I'm not sure because of the way we're doing this. I did want to point to the court to another case with respect to this issue that's been drawn back to the merger issue that I raised, and that is the point is whether or not it's a continuing offense. Kidnapping is a continuing offense. So, for example, if someone is moved, an asportation occurs, all the places during that movement are one crime. And I'll cite to the court Hill versus the state, 279, Georgia Act 666, a 2006 case that's cited in Brower versus the state, 298, Georgia Act 699, a 2009 case. It says that the offense of kidnapping is complete when, in this instance, Brower seized the victims, forced them to the back office in the case of the office staff, and when he taped up and moved the attorney from place to place in the office. So the movement is the question is, if kidnapping is not a continuing offense, then is false imprisonment, and I've done a search and I just don't have the answer to that.
And, yeah, we'll keep the state to its argument. Understanding that with the kidnapping, the issue here, I think, is slightly different. As I understand what the state's arguing is the way that false imprisonment and the attempt was alleged in the indictment was that the attempt occurred on Burford. There was an intervening interval. And then later, short period later, but later, there was a completed act on Holmes. Okay, that's the argument that I understand is being presented. And that's why I'm going to look at the merger part of it. Now, how that fits and whether or not it merges, I'm probably going to take a few more moments to think that through and how that works. But that's what I understand we're looking at as far as the legal issues. I understand the kidnapping part of it. You have a kidnapping, just because you move them within the office, we're not going to allege it. Flip side of that is, I mean, you look at some other statutes like the, I won't tip at windmills, but when you look at police chases, I mean, you can be charged with obstruction 5 times in the same chase. So, I mean, the issue may seem simple, but it's not. But this is the way I'm going to approach it. Okay.
Thank you, Judge. And I believe the reason for the merger really comes down to the issue of double jeopardy, because you have to put the defendant on notice, because you do not want there to be an opportunity for the state to come back with double jeopardy, which is why you want to get as specific as possible, and which is what we did in order to designate these 2 separate instances in time and in place. So that is the state's argument as far as count 9 merging into count 8. And that is what I have for Mr. Goff. Now, Your Honor, with regard to the legal argument that Ms. Hogue made on behalf of Greg McMichael, actually, Noel was then cited in the case of Jeremy Scott, who killed Dexter Holliday. It was a Fulton County case. Embarrassed to say it was my own. And in that case, we had to resentence Mr. Scott because what the court did was sentenced him on the felony murder conviction, but then actually when he was found guilty of possession of a firearm by a convicted felon, the court went and took the possession of a firearm by a convicted felon, merged it into the felony murder, then merged the felony murder into the felony murder for the armed robbery. And the court went and cited to Noel. And this is Scott versus the State, 302 Georgia 29. It's a 2017 case. The state notes that, based on Noel versus the state, the trial court erred in merging the felony murder convictions and then merging the predicate felonies into the remaining murder conviction. When the trial court sentenced Scott on count 2, the felony murder based on aggravated assault, count 3, felony murder based on possession of firearm by a convicted felon, was vacated by operation of law. Therefore, count 6, possession of a firearm by a convicted felon, then cannot merge into count 3, which stands vacated. We therefore vacate the merger of count 6 into count 3, meaning the possession of firearm by a convicted felon, into the felony murder that it's based on, and remand for resentencing on count 6. Now, factually, you are a convicted felon at the moment you're shooting that person. It happens at the exact same time. So I think that kind of goes towards that, well, if it's all happening at the same time, it needs to merge together. And I will also direct the court to a case I affectionately call the El Camino case. Once again, unfortunately mine. This is Demarcus Graves. It is Graves versus the State, 298, Georgia, 551. Once again, a 2016 case. And at that point in time, basically it said, while the evidence was sufficient to sustain Graves' conviction, we find an error in sentencing. The trial court purported to merge 2 felony murder counts with the malice murder count. The trial court then purported to merge 2 independent felonies, criminal attempt to commit armed robbery and possession of a firearm by a convicted felon, with the 2 murder counts. And basically what they said in Graves was, no, you can't merge the felony murders into murder. You have to vacate them by operation of law. And once they're vacated by operation of law, that's going to leave you with the possession of a firearm by a convicted felon and the criminal attempt to commit armed robbery. Therefore, the trial court is required to vacate that portion of its sentencing order purporting to merge the 2 independent felonies and impose proper sentences on those counts, which I then had to go ahead and do and resentence Mr. Graves to the murder charge with those 2 particular felonies. So there are 2 cases right there that show that that is not the case, because they murdered Mr. Graves while attempting to rob him of his drugs while he was sitting in his El Camino in the parking lot of an apartment complex while being convicted felons. All of that took place at the exact same time. So therefore, Noel does not stand and has been overruled basically by Scott and Graves. So with regard specifically now to Greg McMichael, the idea that there was no vigilantism here because after they confronted people, after they took their guns to confront people, after they confronted those people with those guns, then they would call the police, is somehow a neighborhood watch situation. As Officer Rash testified, they're supposed to be witnesses. That's what Neighborhood Watch is there for. They're supposed to be great witnesses. Officer Rash said he thought Greg McMichael would be the best witness, being a prior law enforcement officer, that he'd be able to come in and take the stand and say what he saw. That's what Neighborhood Watch is supposed to be, not somebody running after people in a residential neighborhood where there are women and children and people out walking on a regular basis. This was a Sunday afternoon. It's a miracle they didn't run into families taking a walk that day. And on a random day, when the GBI went out with the drone videos and were just going through the neighborhood, they captured numerous people out taking a walk. A family with children were there. So the next point, that Greg McMichael has shown no remorse or empathy because he's unable to. Well, Greg McMichael was a law enforcement officer. But what he did on May 5th of 2020 was release evidence in an ongoing investigation into himself and to his son. Greg McMichael's the one who released the video to the media. He went to Mr. Bryan and said, hey, give me your phone, I'm going to take it to my lawyer, took it to his lawyer and had his lawyer release it publicly because he believed it was going to exonerate him. That's interference with administration of justice. Yes, we did not charge him with obstruction or anything like that, but the fact of the matter is this is someone who was in law enforcement for years and actually actively pursued evidence in a case against him to be released to the media because he believed that that video showed he and his son were not guilty of anything. That's 2 months afterwards. The state's position is he hasn't changed his mind. The state's position is he and his son still believe they didn't do anything wrong. And that is a lack of remorse or empathy. The idea that he did not intend the death of Ahmaud Arbery, once again, he's a law enforcement officer, got a gun, went running after somebody. The jury did find that he intended to commit false imprisonment, criminal attempt at false imprisonment, aggravated assault with that pickup truck, and aggravated assault with that shotgun. And we all know that felony murder has a foreseeability component to it. Ahmaud Arbery's death was foreseeable, and especially foreseeable to someone in law enforcement. The idea that they wanted to get to the bottom of what an unknown person was doing in some neighbor's house, a neighbor they didn't even know, goes back to our vigilantism. This whole idea that they were trying to help the neighborhood out has been an excuse from both Travis and Greg McMichael. Ms. Hogue got up here and said, this wasn't advancing the progression of the crime. And I apologize for this once again, Your Honor, but stop or I'll blow your fucking head off. I think that really advances the progression of the crime. You're threatening to murder somebody. You're threatening to kill him if he does not stop. And referring back to the post records produced in the bond hearing, Greg McMichael was so not paying attention to his job as a law enforcement officer that he was not post-certified from January of 2006 through 2014. He was an investigator in the district attorney's office, and he let his post-certification lapse from 2006 to 2014, 8 years. I won't even go into what that could have meant to those cases that were prosecuted by the district attorney's office. He then lost the post-certification again in 2018, and Jackie Johnson had to make an accommodation and change his designation at his job just so he could keep his job through retirement. This attitude of I'm special and I'm above the law and the law doesn't apply to me and I can take my gun and I can run after people and confront the homeless guy under the bridge and then call the police later about it, that's vigilantism, and that is the main reason. The thoughtlessness, the remorselessness, the desire so to be special and protect himself and his family by taking evidence and releasing it publicly when he knows there's an ongoing investigation is the reason we are asking for life without the possibility of parole. And with regard then to Travis McMichael. There's a reason, Your Honor, you did not grant bond to Travis and Greg McMichael. Mr. Rubin went back to all of those things listed in the bond hearing. The state will also direct the court to things the state presented in the bond hearing, including his text messages with all of his offensive racial animus and language. The jury did find that he had an abandoned and malignant heart. That's exactly what the jury found. They were given that he intentionally went ahead and did this, or the other level, abandoned and malignant heart. In addition, I will remind the court that there's an old saying, the road to hell is paved with good intentions. And it's great that they had such good intentions to protect the neighborhood. But the thoughtlessness, the lack of vision to know how this could go terribly, terribly wrong. And the fact of the matter is, Your Honor, it was a year and a half. February 23rd, 2020. November 2021. Travis came in here and testified. The state asks that you take into consideration his demeanor, his attitude. He said, this was the worst day of my life. Well, how'd that work out for Ahmaud Arbery? Not once did he show any empathy or ability to place himself in the position of Mr. Arbery on the stand. And yes, 4 minutes of conduct. Well, 4 minutes of conduct. Usain Bolt won 8 gold medals. When he runs those races, they're less than 2 minutes long. But the reason he's able to do that, the reason he is able to win, is because of 20 years of training that leads him to those 2 minutes. Those 4 minutes are a reflection and a result of an entire lifetime of Travis McMichael and his attitude, his demeanor, what he believes he's entitled to go ahead and go do. The same applies to Greg McMichael. That 4 minutes of conduct wasn't just 4 minutes of conduct. It was a culmination of vigilantism. We get to go ahead and play law enforcement even though we're not, and that we're going to go out and confront people, and we're going to take our guns to go do it without any real understanding or consideration of the consequences. At this time, for Travis McMichael, these are the reasons that we are asking for life without the possibility of parole. Thank you, Your Honor.
All right. That being all argument and evidence presented, and I say that just to be clear on the record, there had been some discussion with counsel about evidence and the record. The court is going to leave the record open, as I understand it, for what's going to amount to a notice of filing and 2 affidavits, just in order to preserve arguments made during the trial on appeal. I'm going to take about 10 minutes, maybe 15 minutes, and go through my notes, and then the court will pronounce sentence. We are in recess for 15 minutes. All right, we are back on. The defendant is represented by counsel. All right, the way the court's going to address this, I'm going to make a few remarks and then address each one of the defendants with regard to sentencing. And the remarks are intended to be general, but also taken into consideration in the individual sentencing portion of the court's statement. So that's how we intend to proceed. So the court has heard the evidence in the case, has accepted the jury's verdict, listened to the presentations here today in aggravation and mitigation, and candidly have spent a lot of time thinking about this. This is a case that has taken a lot of time and energy on a lot of people's parts, and has been a case of note, not just in this community, but really in a lot of communities. But what we're here today to determine is what an appropriate sentence is, quite separate from the notoriety of the case and any other outside influence that may exist. And so the court is going to be very careful in explaining that the court has considered just the evidence and what is appropriate under the circumstances of this case to consider in the superior court. So that all being said, let me start with this statement. As we all now know, based upon the verdict that was rendered in this court in November, Ahmaud Arbery was murdered. It's a tragedy. It's a tragedy on many, many levels. On February 23rd of 2020, almost 2 years ago, a resident of Glynn County, a graduate of Brunswick High, a son, a brother, a young man with dreams, was gunned down in this community. As we understand it, he left his home apparently to go for a run, and he ended up running for his life. He entered the English home at approximately 1:04 p.m. and left that home at about 1:08 on that day. At 1:14, Greg McMichael calls 911 to let them know that there's a black male running down the street. And within moments, Ahmaud Arbery is shot and killed. The three men that are now before this court chased him in a residential neighborhood for at least 5 minutes in pickup trucks, armed with a shotgun and a .357 revolver. The state mentioned this today about the time period, but I do want to put that time period in context. And the only way I could think to do so may be a little theatrical, but I think it's appropriate. I want us to all get a concept of time. And so what I'm going to do is I'm going to sit silently for 1 minute. And that 1 minute represents a fraction of the time that Ahmaud Arbery was running in Satilla Shores. That's approximately a minute. Again, the chase that occurred in Satilla Shores occurred over about a 5-minute period. And when I thought about this, I thought from a lot of different angles, and I kept coming back to the terror that must have been in the mind of the young man running through Satilla Shores. The jury heard the evidence and returned a verdict. And what a difficult job they had under the circumstances. Without any comment on the verdict itself, I think all counsel will agree and accept that this was a very difficult case to even get a jury impaneled on. And there are issues out there with regard to the jury that were brought up in the press and elsewhere. But I want to give credit to those members of the panel, not because of their verdict, just because of the fact that they were willing to go through the process that they went through with the state, with the defense, and with this court. We're here today to sentence the defendants. In discharging the duty, this court is required to consider all mitigating and aggravating circumstances. The court has considered those circumstances, including but not limited to all aspects of the crimes charged, the past criminal record or lack thereof of the defendants. I've also considered any lawful evidence which tends to show the motive of the defendants, their lack of remorse, their general moral character, and any predisposition to commit other crimes. Now, I think in this case, the record speaks for itself, and the defendant's own words, I think, guide this court with regard to sentencing. Went back through my notes and other resources to pull some of the quotes that we have in this case. I'll start with Greg McMichael. In my opinion, Greg McMichael, very early on in this, tried to establish a narrative. He made comments like, Ahmaud Arbery was trapped like a rat. Stop or I'll blow your, and I won't repeat it again, head off. He effectively admitted that he wasn't sure what Ahmaud Arbery had done wrong. Quote, I don't think the guy has actually stolen anything out there, or if he did, it was early in the process. But he keeps going back over and over again into this damn house. Again, back to the narrative. He told Travis, you have no choice. Told another individual at the scene, this guy ain't no shuffler. This guy's an asshole. He commented that he wanted him, Ahmaud Arbery, to know that we weren't playing. If I could have gotten a shot at the guy, I would have shot him. Travis McMichael claims he was in shock. But it's interesting because he talks about his concern for his child and his own well-being. Part of this was while the victim was actually laying there in the street. Commented, this is the worst day of my life. Well, I think it's been touched on here today. There were other individuals that were impacted. I look at the video of this incident. When I say the video, I think everybody knows what we're talking about, but there was one part of it that struck me as absolutely chilling, and that is, I believe it's in the enhanced video provided by the GBI. There's a frame where I believe Ahmaud Arbery, it looks to be, if he's 20 yards out, that may be close, 30 yards out. And it's the frame of Travis McMichael lifting the shotgun to fire at Ahmaud Arbery. And you watch that with context. And when I say context, after hearing the evidence in this case, again, thinking about a young man that had been running at that point for almost 5 minutes, and it is a chilling, truly disturbing scene. And we got there because Travis McMichael's father saw Ahmaud Arbery hauling down the street and calls out, let's go. At that point, Travis McMichael, despite whatever may have been going on in his life at that time, with regard to family or otherwise, just goes, grabs a shotgun, and goes because he assumes that it is the right thing to do. Ahmaud Arbery was then hunted down and shot. And he was killed because individuals here in this courtroom took the law into their own hands. Mr. Bryan, He joined in after calling out to the McMichaels. Y'all got him? Claimed he didn't know what was going on, but obviously wanted to know if this individual who was running through the neighborhood, who he didn't know, had been caught in some way. He said, quote, I figured he'd done something wrong, but I didn't know for sure. All right, that wasn't actually this quote. Those quotes are two separate quotes. Didn't know for sure. I thought he would get away. And this is the part that is disturbing to me with Roddie Bryan. If the guy would have stopped, this would have never happened. All of these quotes give context, I think, to the video that we saw during the case. And Miss Wanda Cooper-Jones this morning made a statement that I think, when you look at these statements and you see the videos, is very true. And that is, she said, when they could not scare or intimidate him, they killed him. There's been discussion about remorse. And I agree with counsel that it is dangerous for defendants who have multiple prosecutions against them to make statements of remorse. But remorse isn't something that is simply a statement of regret. Remorse, I think, can be determined by looking at somebody's reaction to difficult circumstances and the reality of the situation that they're in. Again, it doesn't require an apology, and quite honestly, sometimes apologies are made simply to get past problems. Remorse is something that's felt and demonstrated. In this case, getting back to the video, again, after Ahmaud Arbery fell, the McMichaels turned their backs. It's, again, a disturbing image, and they walked away. This was a killing. It was callous, and it occurred, as far as the court is concerned, based upon the evidence, because confrontation was being sought. I think the statement was made during closing arguments. It's interesting to note that the most violent crime in Satilla Shores was the murder of Ahmaud Arbery. So sentencing does not generally provide closure. I think Ms. Wanda Cooper-Jones also talked about closure. But I don't find that it really does, and I think that's an unfortunate thing. Because in this case, I think many people are seeking closure. The mother, the father, the community, and maybe even parts of the nation. But closure is hard to define and is a granular concept. It's seen differently by all depending on their perspective and the prism of your lives. Instead of closure, maybe we'd best see today's proceeding as an exercise in accountability. We are all accountable for our own actions. Sometimes, in today's day and age, that statement is lost upon many. And today, the defendants are being held accountable for their actions here in Superior Court. Today demonstrates that everybody is accountable to the rule of law. Taking the law into your own hands is a dangerous endeavor. I'm not sure how this comes across. I'll say it anyway. I think ultimately, with regard to the murder of Ahmaud Arbery, it holds us all accountable. I've read somewhere, and I don't remember where it was, that at a minimum, Ahmaud Arbery's death should force us to consider expanding our definition of what a neighbor may be and how we treat them. I argue that maybe a neighbor is more than the people who just own property around your house. I also believe that in assuming the worst in others, we show our worst character. Assuming the best in others is always the best course of action. And maybe those are the grand lessons from this case. I will let others spend as much time as they want writing about it and talking about it. But those are my general thoughts with regard to this case and sentencing. That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7. That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder, defendant was found not guilty. Count 2, felony murder, life without the possibility of parole. Count 3, felony murder, vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years. Roddie, Bryan, I do want to separate a little bit because the state is making a different recommendation. And despite the back and forth that Mr. Goff and I had during this case, I do want to point out a couple things that he raised that I think are appropriate to raise with regard to the sentence. As far as the remorse, I think Roddie Bryan stands in very different shoes. It is obvious from the beginning that he questioned the tragedy that had occurred at the scene and was on, I believe, I can't remember whose body cam, but the body cam, in fact, questioning whether or not what had occurred, and then took steps early on in this process, I think, that demonstrated that he had grave concerns that what had occurred should not have occurred. And I think that does make Mr. Bryan's situation a little bit different. However, Mr. Bryan has been convicted of felony murder. And I do not believe it can be disputed based on the facts of this case that the verdict was an appropriate verdict based upon the evidence presented, at least. And when I say appropriate, what I mean is legal. Because I believe there's been some discussion about some differences between Mr. Bryan and the McMichaels. There may be some differences, but it does not change the fact that was it not for the fact that Mr. Bryan used his vehicle in a way to impede Mr. Arbery's course of travel, this may not have ever occurred, and that is sufficient for felony murder. He did cooperate with law enforcement. I will point out Mr. Goff, 1710-1B. There's actually a case out of Chatham County that says it would not apply under the circumstances of this case. So the court, recognizing that Mr. Bryan's position is different, again, Mr. Bryan was found not guilty on count 1 and count 2. The court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into count 3. The defendant is sentenced to 10 years consecutive to count 3 on count 8 and 5 years concurrent with count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence. Those are the sentences. The court having pronounced sentence, first with regard to Travis McMichael. Mr. McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And just to be clear on the record, I'm going to go through the statement with regard to each defendant. So as to Gregory McMichael, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. And then finally, Mr. Bryan, you are hereby notified that under the law of Georgia, you are entitled to appeal the guilty verdict of the jury, and if you decide to do so, you must file your appeal within 30 days of this date. You are also informed that you have the right to retain a lawyer of your own choice to represent you on your post-trial motions and appeals to the appropriate appellate court of Georgia. If you cannot afford a lawyer, the court will appoint one for you. You are entitled to and will be given a transcript of all pretrial, trial, and post-trial matters without cost to you if you cannot afford a transcript. You may file a motion for a new trial, or you may appeal your case directly to the appropriate appellate court of Georgia for review. You are also advised that the statute of limitations for habeas corpus in this state is 4 years in the case of felonies and 1 year in the case of misdemeanors. The statute begins to run from the date the conviction becomes final. I don't have a blue or black pen. Is there a blue or black pen down there? Thank you. The court has executed the statement of appeal for Travis McMichael, Greg McMichael, and William R. Bryan. If I could please have counsel and the defendants execute the statements of appeal to confirm they've been given, or the notice has been given. Anything further from the state?
Yes, Your Honor. The state would ask for a condition imposed along with the sentence, and that is this, that the defendants are not allowed to make any money off of their actions, such as a book deal, a movie deal, social media deal, or anything along any way, shape, or form, make any money off of this experience, this conviction, and this trial. And that should any money be made, that it go into a fund for the Arbery family. And I've had this condition imposed before, and given the nature of this case, we just seek to make sure that, based on their actions, having been found guilty of murder, that they do not then reap some sort of profit or benefit off of their actions via such remuneration to or from anyone in the form of, like I said, book deals, movie deals, consulting fees, or telling their story to someone in exchange for money.
There's a statute on this, but maybe I'm wrong.
It's not a SAM statute in other states. I'm not aware of Georgia's, but there is. I assume.
Yeah.
Cite it.
Well, yeah, let's do this. I submit something more formal to the court. I'll go ahead and take a look at it.
Thank you, Your Honor.
And Judge, well, when the court does that, my only concern is how that would impact Mr. Bryan's ability to raise money for his defense, for his appeal. I wouldn't want to be in a situation where he couldn't do that inadvertently because of a sentencing condition.
Yeah, no, I understand the request, but I don't want to just offhandedly grant the request without understanding exactly what the terms are that the court is seeking. So I'd like something in writing from the state explaining what exactly the terms are that the state would be seeking with regard to the condition, and then I guess address that once that's come in more formally with defense counsel.
Thank you, Your Honor.
Anything from Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
All right, we are adjourned. Thank you.